classic confrontation with respect to large-scale products, but in our daily lives we see individual products that aren't made right too, that just, they had a bad day. They didn't assemble it right. They left out a bolt, they left out a nut. Firestone's the bigger example where they just did the whole line wrong.
You bring up a really important question, because I think companies, even though a lot of us tend to think of them as these, you know, big abstract things, they're made up of people. And just because an individual product, one on a line, is made badly, does that mean the company should get into big trouble?
Absolutely. We've decided as a society to shift the burden of that bad product from the manufacturer, who had the ability to stop it, to the manufacturer. In other words, from the consumer, who has no real ability other than to trust the manufacturer that they have a safe product, to the manufacturer. So yeah, the manufacturer's liable if they made 10,000 bad products, or if they made 9,999 good products and only one of them caused a consumer to have an injury. Create a product and market a product that meets reasonable consumer expectations of safety. Consumers have a right to expect certain levels of safety. We expect knives to be sharp, but we don't expect the handles to break. We expect our automobiles to drive a certain speed, maybe not 210 miles an hour, but we expect a certain reasonable speed out of them. If they make a product that meets our reasonable expectations, they're probably going to be okay.
Is there any definition in the law, though, of what reasonable is, or is that one of those great, it depends on the individual case?
There's a word used in the statute called not merchantable. But that generally
that clears it up, doesn't it?
That generally is going to be defined case by case by juries. Each state is going to have an opportunity to consider the product sold in their state, and that's a good part of the law. Used cars, for example, if we look around town, we see Honda Civics have become cars that everybody are souping up. Manufacturer could say, we didn't anticipate people putting that much horsepower in our car. Maybe the first one they could say that, but after a while they start to see that people are using it that way, and then it becomes it's no longer abuse. Then it becomes a foreseeable use. A fun one's a champagne bottle.
Yeah.
I think many people have the opportunity to open champagne, and we're talking inexpensive champagne with a plastic cork. The manufacturer should know that that cork will fly out. The consumer, though, has an expectation that perhaps it will only fly out in certain circumstances, when they want it to, when they push it up with their thumbs. The defiance of that expectation might be that at room temperature it flies out and hits you in the eye.
You take the little hood off, you put it down for a second, you're not thinking that that thing's just going to pop up on its own, but it can.
It can, and the manufacturer knows it should, and so perhaps they should take that into consideration, the manufacturer. But this bottle has a warning on it, and it says it could fly out at any time. Is that adequate? That's something that juries can decide.
That was
case by case basis.
Going to be my next question. Do warnings, manufacturers may say, okay, you know, we're going to warn people. Does that let them off the hook? Well, we put that sticker on, you should have known.
Well, the engineering hierarchy that all products should be made with is design it right, design it safe. If you can't design it right or safe, guard it. In other words, if there are inherent dangers you just can't do anything about, like a punch press, make it so you have to put two hands out and a guard comes down. And then the third and last way is warnings. Warnings are the last resort of the manufacturer.
Well,
they should accompany, every product should have good warnings and instructions. In that group of products I first talked about, the ones that are just Monday morning products, it didn't come out the way they intended. It's pretty clear that if they deliver your car and they forgot to hook the brake pump up, that's not a big deal. But if you get to the design, could it have been a better pump, a different kind of pump line, a different type of brake fluid? That's design issues, and that is a gray area. What are the number of people we will injure versus the cost of redesign? They were proven wrong by juries who said, we will not tolerate that in our society for you to put your profit motives over the cost of human life. And I think that they won't do that again. And that's one of the real beauties of products liability law.
Is that, though, one of the reasons now that we may see things going almost, in a sense, the other way? We were talking about warnings a moment ago. You go to a hardware store and you buy a ladder, a very simple device. Most people know what ladders are used for, and if you get a tall enough one, you kind of know that if you get up there and you fall off, you're going to get hurt. But still, you'll see ladders just plastered with warnings these days.
Well, those warnings are important. Not everybody knows the right angle for a ladder. Through this system of juries bringing back verdicts against manufacturers who didn't have the right warnings and didn't have the right instructions, I think those warnings provide us information that is useful to us every single day if we use that kind of ladder.
Okay. Recall.
The system of recalls is so full of political intrigue, for lack of a better term, that it's really not much of an indication to us. The lack of a recall may have been a political decision, the lack of a recall. In fact, the Ford Pinto decision was actually discussed in the Oval Office. So it gives you an idea of how politics are involved at the highest levels, particularly with huge profitable products and huge profitable companies. First thing we're looking for is the 10 years, because after 10 years, the only thing we can rely on in Georgia law is warnings, but we also have the 2-year rule. And it's important for people to understand if it's been more than 2 years from the date of the injury, unless there's a child involved, we can't do anything. But this is the kicker, and this is the scary part that we see every day in our practices. At 9 years and 10 months, we only have 2 months to get that lawsuit filed, even though it's less than 2 years from the date of the injury. If it's 9 years and 10 months after the time it was first sold for use by consumers, we have 2 months or it's gone forever. Mm-hmm. And that's an important point, and that's why people who feel like they've been injured with a product that they're not sure of the age need to move fairly quickly.
Well, here's one I haven't even thought of. I mean,